Hi, I'm Greg Doe with Dell Disability Lawyers, joined by attorney Cesar Gavidia, and today we're doing our Ask Our Lawyers a Question series, but we're going to focus these questions on Guardian Disability Insurance Company, and more specifically we're going to get into questions associated with the appeal of a Guardian Disability denial. So the first question that comes to mind, which is one of the most common ones we get when people call, is I've been denied my Guardian Disability claim, but can I really win this appeal? And by that I mean is, do they ever reverse these denials?
They absolutely do. You absolutely have a very good chance of winning your appeal if you address the basis and the reasons for denial appropriately. So it's important to really, first, when you get your appeal, you don't panic. You don't call the insurance company. You don't call Guardian immediately and tell them, I'm appealing. I need to appeal this right away. What do I need to do? I know it may be someone's initial response to something, that initial impulse to want to do that, because they're kind of spiraling down this whirlpool of anxiety. How am I going to survive for the next however many months while I recover from this problem? Or maybe I don't know what's going on and I may need to be out of work indefinitely. What am I going to do now if since this disability insurer denied me, I was relying on this. So it's really important not to panic, because if you panic and you just tell them you're appealing without really addressing the reasons for denial and ensuring that you're submitting the best comprehensive, most exhaustive appeal possible, then they're more than likely just going to deny it again. And at that point, it's going to be a real serious problem for you.
Okay. So along those lines, someone will then say, well, what do you think are my chances of winning? And what do you need to know in order to make that evaluation?
Sure. So the first thing we usually do when someone calls is I ask them, well, provide me with your policy and provide me with your denial letter. And sometimes I need a little more information. There may be some claim forms or records that we need before we could kind of do a full assessment. But once we look over the denial and the policy, we can get a general sense of whether we could help that person win their appeal successfully. And from there, what we do once we start representing someone is request a claim file. And the reason we want that claim file is because it's going to give us all the information they used, all the documentation, all the internal notes, all the reports that they used to make that decision to deny them, so that then we could hyper-focus in on those reasons and go in and provide any additional medical support or expert opinions or reports that we need in order to get that appeal decision overturned or that denial decision overturned.
When you're evaluating the claim and you make a determination and say, okay, I think I can help you, I'm going to take this claim on, and you put together the whole appeal, which we'll talk about how long that, different question in terms of how long that takes you, and every case is different. But once you finally submit this appeal, who is the person at Guardian that's actually making the decision as to whether or not they're going to reinstate benefits or uphold the denial? So
once the appeal is submitted, many people think it's going to go back to the same person that made that initial decision. If that were to occur, then it really wouldn't be a full and fair review process, because that person's already coming in to reviewing your appeal with all these preconceived reasons as to why you're not entitled to these benefits, right? Because they're the ones who put together that initial denial. Even the original medical personnel that they used, none of those people are involved in the appeal review. So it's really intended to be what's called a de novo review in the legal world, a review anew. So it's going to go to a new appeal specialist, a person who's supposed to be trained in assessing and reviewing appeal of denials or arbitrary decisions, and new medical personnel. So once they receive it, that appeal specialist is going to assess, well, what kind of doctor am I going to get these medical records to once we compile them all? What kind of vocational assessment do we need to do? Do we need to put this person through an independent medical exam? So all these things are going to be decided by this appeal specialist. Once the appeal specialist gets back the opinion from their medical doctors or the third-party doctors or medical reviewers that they reach out to, and get back a vocational assessment if they do one, then they're supposed to be the person who's making the decision based on all of that information, based on all of the information we've submitted on appeal, and whether that original decision was wrong and overturn it.
All right, so that leads me to my next question. So the disability appeal specialist is the one who makes the decision, right? But you did mention they're going to send it out to a doctor or an internal team of doctors that they have to review the appeal that you've submitted on behalf of the client. If the internal team or the external doctor that the insurance company hires comes back and says, I don't see any restrictions or limitations here, how does the appeal specialist who's making the decision now make a determination in weighing the evidence that the disability appeal specialist for Guardian has obtained from their own person they hired, and the evidence obviously of the claimants treating doctors that you've submitted, and say, I'm going to pick my company's information or I'm going to pick the claimant's information?
Yeah. Well, in a perfect world, you would assume that they're going to weigh all that information the same. In other words, independently and fairly, neutrally. But it's not necessarily a perfect world. We often see that when a claim gets denied, the doctors, the claimants, treatment providers, and the physicians may have been providing just the right support, right? Explaining what the restrictions and limitations were, explaining why that claimant wasn't able to work or to have the physical ability to, or even mental ability, cognitive ability to functionally do their occupation or a gainful occupation. But then Guardian goes and finds an opinion from a doctor that says, well, I don't see that the medical records support this doctor's opinion, or that there's support in the file to establish that there's restrictions and limitations that would prevent this person from working in their occupation or a gainful occupation. And what I mean is, more often than not, is 9 out of 10 times they're more than likely going to go with the opinion of their doctors. So even though the appeal specialist is the one who's supposed to be obtaining all this information and balancing it and saying, okay, where does the weight of the evidence here, where is it leaning? Are we going to approve this person based on the 3 doctors that they have that say they're disabled and the functional capacity exam that they submitted? Or are we just going to go with the opinion of this one doctor that we selected? And sometimes they say, well, why don't we then have this person examined? And they may send them out to an IME. Mm-hmm. And, maybe that IME comes back and says, well, yes, this person does have these limitations and they're not capable of engaging in work. I think that would be perhaps the fair way to do it. And if that were to happen, then they would presumably be approved. But unfortunately, like I said, it's not a perfect world, and they often just go with the opinion of these medical doctors that they hire.
So I want people, going through this denial from Guardian to understand that you can put together this appeal and send in your information, but 9 out of 10 times, and it's probably even higher than that. You said 9 out of 10. I would say 98 out of 100 times, the disability appeal specialist from Guardian is going to adopt the opinion of whatever the doctor is that Guardian hired, right? Mm-hmm. So we know that, and I want people out there to understand that. So the question, and what we want to tell people, is the way we combat that is to put in and obtain in the appeal evidence that is so strong that no doctor, no matter who they send the information to, could reasonably look at that information and disagree.
Right.
And that's the way to really win these appeals, is you've got to get super strong evidence. Now, I tell people, I know you do too, that 80% of the work that I'm going to do for you as your lawyer representing you on this appeal is obtaining all of that additional evidence that I want their reviewing doctor to find in your favor. But I also know, based upon my experience, based upon the case law, based upon handling thousands of these, that if their doctor still disagrees, that the judge is likely going to find that it's ridiculous that their doctor didn't agree with our treating doctors. But you have to know how to put all that together. You have to know how to communicate with the doctors. You have to do custom attending physician statements like we do. You have to have functional capacity experts, vocational experts. You've got to tie it all together, which is crazy because there's such a burden on these claimants to be able to try to do this on their own. And Guardian often sends a letter, like you started this video off by, where they'll just say, hey, submit an appeal. And basically, like, it's almost as if you say, they make it like if you have a problem and you're at a restaurant and you say, can I see the manager? Like, you're just going to call someone else who's going to say, take a second look at it.
Right.
And yes, it is a second look, but it's not just like some customer service person who's just saying, hey, I'm sorry about your experience. I'm going to look it over and try to make it right for you. You have to go, it's completely different. You got to go above and beyond. You got to submit all new information, and it is a fresh look. And that is one benefit of ERISA, that it's a completely new look with new people. But you got to do it the right way, and you also got to think about, if I don't win this, what's it going to look like in a court? So that's the key for me in these things, is that, we say, yeah, the appeal specialist makes a decision, but they really don't. I mean, they really do, but they're really relying on
all
adopting the decision of somebody else. There's so many questions with Guardian, and we've answered so many in general with all these appeals, but I think the other biggest thing is for the claimant who's sitting with their denial letter, how long is this process going to take on average until either I get money or I win my appeal, or if I don't win my appeal? If you can answer this question in like a minute and a half.
So once the claimant receives the denial letter, it will inform them that they have usually 180 days to appeal the decision. That's 6 months. So it may seem like a long period of time, but you also have to compile a lot of information and get a lot of evidence so that you have the highest likelihood of success on winning that appeal. So you have that 180 days, and then from the time that appeal is submitted, they have 45 days to review the information, do whatever they're going to do, and make a decision. Oftentimes they don't make the decision within that 45-day period, and ERISA allows them an additional 45 days to continue their review. And in some cases, they're able to toll the time based on information they're waiting on, or if you've submitted additional records during the pendency of that appeal review, so they'll extend it for some period based on kind of a mutual agreement. But generally it could take almost up to 180 days to 200 days, just depending on from when you get your appeal in.
Okay, so you're saying give or take the whole process can be, the 6 months plus another plus another 45 and 30, so another 3 months, 3.5 months.
Right.
So you could be looking at 9 months down the road. And then I usually tell people, if you don't win the appeal, which is why it's so important to try to really win your appeal, you're looking at another minimum 6 months to a max of maybe 2 years, if you have to file a lawsuit. And then if you win the lawsuit, there could be another appeal. So you really want to do every single thing you can to put yourself in the best position to win this appeal. And so we always tell people that we're available for free consultations to review their appeals if they've been denied. And no matter where they live in the country, we're able to assist them because we do these on a nationwide basis, just like Guardian sells these policies to claimants all over the country. So if you're someone out there who has any questions, feel free to ask your questions on our website or reach out to Caesar or myself. We're always available to help you, and we look forward to speaking with you.